charge on the National Aquatic Centre. At issue here is a VAT charge of over €10 million which Campus and Stadium Ireland sought to levy on Dublin Waterworld Limited, which had won the contract in 2003 to operate the Aquatic Centre, which is commonly known as the National Aquatic Centre. This report looks at how a state body, Campus and Stadium Ireland Development, pursued and was allowed to pursue an issue that has run up a large legal bill and other costs which have not been quantified. In circumstances, even if the litigation was successful, the state would not have benefited 1 cent. What we set out to examine is why this was allowed to happen. What concerned the committee was that in 2004, both the CNAG and Attorney General told the Department of Arts, Sports and Tourism and CSID to use common sense and to forget about the issue. This litigation should never have been pursued for 2 reasons. One I have already outlined above, and the other is that there was no benefit to the state, and the second is that the case was based on a flawed legal strategy. When construction commenced in the NAC, the law was clear in that the VAT paid on construction could be recouped as the VAT charge could instead transfer to the lease. However, before the lease was signed, VAT law changed, and only economical leases which passed the economic value test could have the VAT charged on a lease. In this case, the state's valuer, the Valuation Office, put a valuation on the NAC which meant that it failed the economic value test, and a simple solution to the whole issue in 2002 was for the Department of Arts, Sports and Tourism and CSID to go back to the Department of Finance and tell that it was a change of VAT law. The cost of the building, the NAC, will be €10 million more than budgeted for, but that the state would not lose out as there was not recoupment of VAT due on the construction costs. This of course did not happen. What happened instead is that because the guidelines of the Revenue Commissioners had not been updated to take account of the 2002 change in the VAT legislation, CSID, on the advice of its financial advisors, relied on these guidelines to take a case against Dublin Waterworld. VAT law is complex, and there are guidelines produced by Revenue which ordinary taxpayers can use to ensure that they are complying with the law. These guidelines carry a health warning that they are not to be used as an interpretation of the law, and yet CSID and its highly paid advisors constructed a case on these very guidelines. If I was going to the High Court in the morning, I would not rely solely on guidelines, even if they supported my case. The report concludes that the advisors did not do the job that they were paid to do. Revenue, which had known about the case since 2002, not only failed to update its guidelines, and this is a critical failure as the update that was required was because the change made in the Finance Act 2002 was an anti-tax avoidance measure. But knowing the details of the case and the fact that it could have lost money if the VAT and the construction charges were recouped, it sat on the fence between 2002 and 2010 when the Supreme Court made a ruling. Revenue should have taken a stronger stance when approached about this, and we described its handling of the whole issue as careless. It should have left CSID in no doubt in 2002 that pursuit of the VAT issue was going to be very difficult. Revenue did not do its job in this regard. One of the reasons given to the committee by the accounting officer for pursuing this VAT issue was that CSID and the Department of Arts, Sports and Tourism had no option but to pursue it because the then Department of Finance said it had to. The support for this stance is very light and is based on a memo which contains oral advice from the Department of Finance. We conclude that either the Department of Finance was not fully aware of the details of this case and the fact that the state would not benefit from the action when it gave its advice, or that the officials that dealt with it were aware that the lease had failed the EVT test, but either way, it should have taken a stronger stance when it was contacted. and it too could have stopped this litigation at a much earlier stage. The Office of the Attorney General gave advice in 2004 to use common sense and forget about it. It subsequently gave advice that the issue should be reviewed as part of an overall legal strategy in 2005 and thereafter, and especially after 2005, when Dublin Waterworld forfeited the lease on the NAC. The issue seemed to fall off its radar. It too needed to look at its procedures and not allow the state get involved in protracted legal cases where they would see no ultimate benefit to the state. Once the Attorney General's office became involved in the issue, it should have ensured that it was not sidelined as the VAT issue wound its way through arbitration and the courts. The Department of Arts, Sports and Tourism no longer exists, but it effectively was the shareholder of CSID, and it should have taken a stronger overview of this case and called a halt to the case, having regard to the fact that the case was not only incurring costs, its job was to protect the taxpayer, and it failed in that. Finally, CSID withheld the Valuation Office report, which would have proved that the lease had failed the economic value test in Dublin Waterworld. Just because a report does not support one's case is no reason to suppress it. CSID did not act in a way that one would expect a body that is effectively a state company to act. CSID has paid enough for advisors down through the years. It should have been more transparent in relation to the VAT charge. By not sharing the report of the Valuation Office, it acted inappropriately. The report concludes that this case should never have been taken. Lessons need to be learned from it if we are being critical, and it is because time and money and resources were tied up on the case which would not have yielded a return, and because one side had the state's resources behind it in litigation and took that case against the company, even though it had been properly advised, it would have known that it was unnecessary. In summary, CSID failed by not sharing the report of the Valuation Office with Dublin Waterworld. Its highly paid advisors should have forewarned them that its VAT strategy was flawed. The Department of Arts, Sports and Tourism failed. It should have cried stop. Revenue were careless in its approach. They should have got off the fence much earlier. The Department of Finance gave advice that went against common sense and did not take into account the Finance Act of 2002. And the Office of the Attorney General allowed itself to be sidelined after giving common sense advice in 2004. That's the report and its findings.